You're actually in for a real treat again, I will say for the third time this morning, in being able to hear from Judge Kazen, particularly around implementing warrants around chemical dependency and some of the nuances of balancing civil rights, need for treatment, public safety. And so today he's going to talk to us about practical considerations and give us kind of some insights with his experience in Bexar County and then also on the Judicial Commission on Mental Health. So please help me welcome Judge Kazen.
So I'm batting cleanup, right? And so my name is Judge Kazen, Oscar Kazen. I've been fortunate enough to have been wearing that robe for over 20 years now. Are there any judges in the room? A few of you. Fantastic. I love you guys. Because this is what I do. Nonetheless, in those 20 years, I have been a criminal court judge. I've done family law. I was the mental health associate judge tasked with all the commitments and civil commitments, and now I'm the presiding judge in Probate Court 1 for some time now. Which is tasked with doing all the commitments. Underneath me now, I have 4 associate judges, one of which is here, Erica Moe, who has taken on the lion's share and role of the day-to-day activity in our AOT. And when they called me, and I've given this speech a million times, by the way, have any of you watched the podcast that the commission put together on AOT that I gave? It's not very many people know about it. Good, then everything I'll say will be funny. I'm not sure I'll be brilliant, but I know that you'll laugh, you'll cry, it'll be better than Cats. So I had a choice. I could wear a suit today. Instead, I decided to wear the brightest red Guayabera I could as a segue into the ethics portion of what we're going to talk about. So in addition to speaking to Chapter 462 of the Texas Code of the Texas Health and Safety Code, hang on a second, I'm going to figure out how to read that clock. So that clock is, we're still on break, aren't we? We're good. Oh man, now you gave me more time to talk. All right, back to this. As a segue, I discussed it with them, I talked to them and with the people who put the summit together, and they said, we really need some ethics discussion, so would you mind filling in about 15 or so minutes speaking to something which would help with our ethics, both as to caseworkers, judges, etc. So the first 15 minutes is about why do we do what we do, right? Why are we here? Why is it and what is it that drives judges from across Texas, caseworkers, staff, doctors, from the medical psychiatric profession, from sobriety, chemical dependency, all together to come and meet? What is it that brings us here? And I think at the heart of it, it is the heart of it. It's why we're here. So I want to talk to you a little bit about my experience as a segue to why we're here and what we're doing. And then we'll segue from there into Chapter 462 of the Texas Health and Safety Code, which is actually entitled The Treatment of Individuals with Chemical Dependency. It covers everything from if you're receiving treatment, just generally what you can and can't do, to voluntary treatment, to involuntary treatment. Little teeny section there that needs a lot of work. Fair enough for everybody? All right. So, why am I here? And when I say I speak to you to motivate you. I have been in that time as a judge through many different elections. One of the very first elections I ever went to, a re-election, was one of those wave-type elections. And I was the guy who had the highest, we had to do these polls at the courthouse, the highest favorability. Everybody liked me. I had the best stats. I was either 1, 2, or 3 in every statistic across the board. And yet in that wave election, I lost by 6 votes. In a county of a few million. Think about that for a second. I could have hugged that table and still been that judge. And if anybody tells you that as we often do as elected officials, well, it's the will of the voters, it's what happened, that's okay, we're going to honor and help the next people who come in. What they don't tell you is that at night, I sat there and cried like a big old baby. All right? And what they don't tell you is that this, and by the way, I am twice the Marine I was 30 years ago. True story. But this big Marine turned into a big crying baby. Because it's hard to do what we do once we do it and help others and not feel a sense of loss. So way back in 2002, I think it was, I was first elected as a county court of law judge. And another judge, Al Alonso, came to me, along with Judge Spicia. Many of you know Judge Spicia. And said, we just got some funding from George Bush to create a drug court. Anybody here know what a drug court is? Everybody does. Can you imagine that the first time I asked that question 20-something years ago, there wasn't a single hand in the air? All right? So, what's a drug court? Well, you know, it's some money, we can get over there, we can get trained. And my first response was, no, I really don't want to do that. Now, back in the day, the early 2000s, the late 90s, all of us who are judges, who here got reelected or elected on anything other than tough on crime? All right? Good luck getting elected with, I think we can help people. All right? In fact, even our code of ethics back then didn't accommodate for specialty courts and what we do within the specialty courts or what we do within therapeutic courts, right? So I really don't want to do it. And Al Alonso, Judge Alonso, no, it's something different, man. It's being able to use the power as a judge. We're going to put him on probation or put him in jail. Let's get him in treatment instead. And the bell went off, and I thought, I think that's a pretty good thing, right? Let's put him in treatment. Because back then in Bexar County, what we used to do when you called it a drug court was we would line up everybody who had been in jail on a misdemeanor offense and line up everybody who had been convicted of the newly developed state jail felony, line them all up in one or two courts on one day. We called it the drug court, and they would sit there. I hereby sentence you to credit for time served. I hereby sentence you to 1 year state jail felony position. Boom, 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 boom. The drug court was a way to empty out the jail. It wasn't what we later learned, that a therapeutic court and what a therapeutic court could do. It turns out, and those of us now, I don't even have to tell you this, you already know it. It turns out that the brain, if it's seriously addicted, rewires, sadly. So if in my life I have 4 cups that experience joy, the smell of rain, the joy of laughter, bacon in the morning, a great T-bone steak. Did I mention I'm twice the Marine I used to be? All right. Those joys are instead filled with, in the receptors in your brain, somewhere about a ½ inch over and about 2 inches down, with the drug. And if you're seriously addicted, all of a sudden it's not just 4 cups of joy. Your brain is rewired to 6, 8, and 10 cups that need to be filled. And when you are on the drug, and it was explained to me, it's as if you fell 1,000 feet from the sky, landed in a warm cloud that envelops you. You forgot everything else that's going around in your life except the joy and pleasure and feeling of that moment. And nothing else touches it. Well, we've come a long way in studying the brain, and if you can keep somebody sober, out to about 90 to 180 days, it's not sobriety, but the brain begins to conceive that there are other ways to experience joy. The brain begins to understand that you can heal. If you can keep them sober a year out, those cups begin to go away. They'll always be there, but all of a sudden that smell of bacon in the morning smells good. The sound of laughter rejuvenates you because you've let your brain heal and rewire. So how do you get them to treatment? I grew up in a year, how many of us are old enough to remember, you can't make somebody quit drugs, they got to want to quit drugs. Anybody here agree? Remember that? Anybody here now know that, with the proper course of treatment and the proper impetus and stimulus, you can actually get somebody to think, hey, I think wellness should be my habit, not illness, right? So back to the ethics. I'm sitting there and I'm thinking, I don't know if I want to be. And then Al says to me, when I was less ethical, the training's in Las Vegas. Okay. And then I drank the Kool-Aid. And then it made a difference. Back to the ethics and why each of us need to be doing what we're doing. So when I lost that election, shockingly, and in fact, the opponent who came out on the last day you could register, didn't even know what was going to happen, right? Not to worry, I was reappointed very quickly thereafter, but when I lost that election, I was sitting on the bench and I was holding my head up high and I was spending my last time on the bench and trying to keep dignity of the profession and doing the line that everybody says, oh, well, it's the will of the voters, we're going to serve to the very end. All the while my gut was churning. Well, I was sitting on that bench in the back of the courtroom, the two double doors open, and this gentleman walks in and he stands there. And I'm kind of wondering, I still have the gallery full of defendants and individuals. Why is he there? And I kind of looked at him, and he kind of walked to the middle, and he stood there looking at me. And then he used the famous words, "Hey, Judge, do you remember me?" And I thought, what a perfect way to end a perfectly crappy year. I'm going to get shot. And he walks up to my bailiff starts to stand up, and he walks up to the bar. By the way, there's no coincidence, that little thing with the little door on it called a bar. It's no coincidence that we also refer to it as passing the bar, getting on the other side. And he walks up to the bar, and he starts to reach in his pocket. Starts to reach in his pocket. And all I could think was, here it comes. Tell my wife I loved her. I kind of smiled. I said, can I help you? He says, yeah. He reaches in, my bailiff's standing up, and then he pulls something out, and he does this. And he tosses it. And I catch it. And it took me about a second. This is going to play back into our friend and the journey for sobriety back there. And it took me a second or two to fumble through them, and it was 24 NAAA chips. Wow. Thank you, my friend. 24 NAAA chips. And it took me a minute to understand the significance of that. And he says out loud to me, he says, Judge Kazen, I know you're stinging. I know it hurts. You don't remember me, but I was one of your very first drug court graduates. In fact, I used to be one of your experiments to see how to make it work. He says, I've been sober for 2 years, over 2 years, and I didn't want you to step off the bench without knowing you made a difference in my life, my kids' life, and everybody around me, you and your team. Wow. And I started talking to him. He says, no, that's all I came to tell you, man. He says, keep those. I have kept, and I get a little emotional when I talk about it, I have kept those chips with me on the bench for 20-something years. That's why we do this. So the story gets deeper. I'm in California, and I'm giving a speech on AOT. And I gave that same conversation about how AOT morphed out of the drug courts, or the way I do it anyway. And this lady stands up. How many of you know what the color of the 30-year sobriety chip is? You would know. It's like a bronze kind of goldish color. And this lady comes up to me and she says, I loved your story. And she reaches in and she says, this is my gold chip. Or it's a bronze actually, but my chip, my 30-year chip. I want you to have it. Wow. She says, don't forget why you do this. And I made a promise to myself that when I'm giving ethics and when we talk about ethics, we're not going to talk about the duty of the judge to always pay humble accord to each and every litigant before him. We're going to talk about what we do and why we do it. We do it for that reason. All of you in this room need to remind yourself, even on the days where you just don't want to do what you're doing, that we are all ripples in a pond, intersecting with each other and changing each other's course, for good or bad. But on occasion, we get to be the stone that causes the ripple in the pond. Be that stone. Okay? So I hope in some small way I've motivated you in my 15 minutes or so of ethics discussions of what we're doing to be that stone. Those chips still make a difference to me, and I didn't even earn them. He's the stone. You think the story is that I'm the stone. He's the stone. Eric, I'm going to call you out. Eric is one of my many graduates from AOT. Our AOT in Bexar County has had phenomenal periods of success and phenomenal periods of difficulty and phenomenal periods of success. It's the course for relying on funding. It's the course of, we're dependent on how many hospital beds are out there, what the capacity is. Do we have a contract with our group home to keep people in transition? How do we adopt when we don't? Sometimes you do great, sometimes you do worse. I gave this the other day, if you all were here. I said, how do you eat an elephant? One bite at a time, but it's still a hell of a chew. All right, you just got to keep going at it. Eric, I don't know if you've had the pleasure of hearing his discussions. He was one of my AOT graduates as well. And he is one of several, but to my mind, a friend and someone who makes a big difference. And I just want to thank you for being here, Eric. So he was seriously schizophrenic, and I may share because I know it's your story, suffering from serious schizophrenia. It took us some time in AOT to get to the point where the treatment that we worked at together worked for him. There were failures even in your journey. But now the ripple in his pond, his ripple affects so many others because he's gotten through school. He's now a subject matter expert. He flies all over the world to discuss treatment and AOT and rehabilitation, and that there is a life after serious mental illness or with serious mental illness. Does that fairly accurately describe it for you, Eric? So for those of you who don't know him, I don't care. He deserves a big round of applause. And going back to, you would think that this speech is about me or you. You are the stone. You seized that opportunity to become the stone, causing the ripples, changing the lives. Be that stone. All right. Good enough for your ethics argument, your ethics discussions? All right. You should be aware that I'm glad you all are here. I am actually on the commission. Are there any other commissioners in the room? All right, we got a couple. You all know that we're not supposed to tell them this, but I'm going to. So these cameras, the commission invested in a whole bunch of money to do this facial recognition thing. So when it's passing around, at the end of this, what they do is they match the faces to the people taking credit for today's hours. So the people who aren't here, that is a true story. So it's hard being cleanup because at the end, most everybody's already leaving. So I'm trying to make you enjoy the last few minutes. So let's transition to the developing thoughts and concepts and processes for chemical dependency. So we're coming full circle, right? For me, I'm one of the first guys to do a drug court, one of the first guys, if not the first guy in Texas to do a true AOT program in court. I've flown all over the country. This is another thing about dovetailing back to ethics. Why do we do it? We don't do it for ourselves. In my community, there's probably a few people here in Bexar County, from Bexar County, they don't know this. I've been in the New York Times. Thanks to Eric, I was in People magazine for a little bit, just a picture there, and a blurb and a mention. I've been featured in the Boston Globe. Hell, I've even been in the Louisiana Picayune. I've been mentioned in several books. I've testified on panels in Congress. I've been probably in 8 different states where I helped rewrite or consult on the law. But I truly believe that each of us have to live by the old biblical prophecy. You can never be a prophet in your own land. You have to do what you're doing because you're helping others, not because it helps you, right? Interesting story, just by way of laughter. So when I came out on the Wall Street Journal, it was actually the 3rd page. Think about that. You flip the page and there I am, big old section. And I was wearing a Guayabera. So for those of you who are not too close and aren't familiar with Guayaberas, this is stitching, all right? And I'm all proud of being on there, and this humbled me really quick. I went to the electronic version, and I looked at the comments, and the first comment was, does anybody else want to iron his shirt as badly as I do? I about fell out of my chair. But we do it because at the end of my life, in creating the ripples, I know and I can rest peacefully knowing I walked that road, and many of us walked down that road to create AOT. I walked that road in Bexar County to create drug courts. Now, many years later, when I say anybody familiar with drug court, all of you raise your hands. That didn't just happen. That was a lot of work. And when you believe in the motto of you're not a prophet in your own land and never can be, it doesn't bother you that nobody remembers that you were the first one that did it, right? It doesn't bother me that, except in this maybe small circle, nobody knows that I was the first guy that got together and figured out how to put AOT together as a court order, as a program. It doesn't bother me that there are other AOTs now which far outshine us. I'm so happy for that, right? So chapter 462, that's a horizon. I'm sitting in my office. I've been a drug court judge. I do the AOT. I know that intervention in the protocol works. I know that a therapeutic court, if done with the goal of involving the participant and making wellness their habit instead of illness, works across the country. No worse than 60%, usually around 70 to 80%. That's pretty darn good in the population that we work for. And I'm looking through the Texas Health and Safety Code, and there's this section called the Texas Chemical Dependency Warrants. Uh-oh, let's hope I didn't spill water on my clicker. There, I did not ruin your clicker. All right, so what is Chapter 462? Chapter 462 in the Texas Health and Safety Code is an arcane, out of date, somewhat clumsy attempt at placing people in sobriety in the day when our state hospitals actually had sobriety centers. Any of you remember the day when our state hospital had a section, right? There's a couple of us who've been around long enough to remember that. At the San Antonio State Hospital, there was this whole wing, and it was usually the kid or the son or the daughter or some influential person who got them in there. But there's this whole wing that dealt with nothing but chemical dependency. And the law, it's pretty much tailored to the days when we had a treatment facility that was run by the state government, right? Well, guess what? That's what we inherited with AOT. But we changed the laws in Texas, we've changed the laws across the country, and now it is what it is. So this discussion here, brief though it may be, is a challenge for you to go home, look at Chapter 462, pull what you can out of it, and experiment legally. See what works and doesn't. So I committed in the last year or two to take a few here and there where I could finagle or goad a treatment center into giving me a free bed, where I could goad a doctor into doing the certificate for free, just to see what would happen. And we put together law enforcement, first responders, Dr. Jason Miller from the PIC team. We put together the Center for Healthcare Services. We put together San Antonio Southside Recovery Center. They gave us some free beds because we had coincidentally contracts for the criminal side. I thought, let's see if this works. Maybe we can make this something. And we tried it through the years. And we tried it on about 3 or 4 people, and we've learned some valuable lessons. 2 of them were tremendous successes. One of them was a success because he got there and stayed sober for about a year or so, but then he relapsed. 2 of the other ones were failures. They disappeared. And we learned what are the gaps in the law that we need to look at. So Chapter 462 covers the treatment of people with chemical dependency. It defines a process for voluntary and involuntary court-ordered treatment, again, in the context of the old days. The purpose of this presentation is to get you thinking about, court-ordered treatment processes as it relates to people with serious dependency. Talk a little bit about the roles that I was able to kind of make work to see if it worked and to see where we needed to fix. Encourage you then to think about that when you go home. And establish a clear and concise, efficient workflow. Guess what? That one, work in progress. All right? You're not going to get that, but we're going to get a discussion about it so that we can together do this. So let me ask you a question. How many people here remember and can tell me who the first person that walked on the moon was? Somebody yell out his name. Neil Armstrong. Good. That side of the class is better than you. All right. How many people can tell me the 3 people who first circled the moon? Not a one, right? So, uh-oh, someone's giving names over there. I'm not even looking up. It's got to be an old guy. No. All right. Frank Gorman, Jim Lovell, and Bill Anders. So all of it's a journey. This is a journey for us. I anticipate that you'll hear us talk about this through time. I anticipate that in a few years you'll hear us go back to the legislature and try to tweak the statute. I anticipate that 15 years from now, when we're old, retired, and I'm in a walker, there's going to be a room filled with people who, when they ask, how many of you know what a civil outpatient treatment court is? Got one? That's what this is about. This is the horizon that we need to explore, and I'm hoping I can excite you a little bit with some humor along the way. So when you take someone and you probe this horizon on Chapter 462, it works, believe it or not, almost exactly as the involuntary commitment. Anybody here familiar with involuntary mental health commitment? It's pretty much everybody, right? It has the same fundamental core that involuntary mental health commitments do, although it needs a lot of refining because we haven't been able to tweak those statutes as we did for AOT way back when. We will eventually, hopefully. There has to be an applicant. That person is typically the district attorney or another adult who files a court order treatment. We know, and what we've learned from mental health court order treatment, having an applicant from the outside of the system really doesn't work. Because if you are going to try to put somebody in an AOT or in a program, you can try to be an applicant from the outside if you're lucky enough to get them to the doctor for assessment, if you're lucky enough to get them to a treatment, if you're lucky enough. Doing it within the context of the district or county attorney means that they're already under our jurisdiction. They're either in a jail or a hospital, so we can direct the treatment, or we can move them from that location to a doctor to get the certificates. So same process, it can be a district attorney or any other adult, but I caution you as we start to explore this, the any other adult part can work, it just doesn't very often work. Anybody experience the same thing? Exactly. All right. The proposed patient would be named in the application. It has to be chemically dependent. Now, what is the definition of chemical dependency? The statute goes on to say it's the abuse of alcohol or a controlled substance, psychological or physical dependence on alcohol or a controlled substance, or addiction to alcohol or a controlled substance. But in order, now that's the dependency, right? But in order to get onto 462, that later section that talks about court ordered compelled treatment, you've also got to be so intoxicated, so I call it controlled by the drug or the alcohol, that you become a danger to yourself or others. It's that same criteria. It's not just, if I want to go drink bourbon all day, I can, as long as it's not killing me and I'm not hurting anybody, right? Not good for me. And I certainly need to be careful that one bourbon doesn't turn into one bottle. In fact, who was talking earlier about the bottle of wine in here, one of the discussions? In the back, the three of us who were being cut-ups just like classmates do at the back of the class, did she say bottle of bourbon or bottle of wine? All right, so it requires, just as in the application, that at some point a certificate be placed together. What's the process? Well, the process, again, similarly simple. There's some distinctions, by the way, when we look at it that we're going to have to tweak. So, for example, when there's an emergency detention that we'll get to in a second, they can only be kept for 24 hours. So, for example, if you're going to commit somebody, and by the way, most of our experience on those 4 or 5 people we did, at least half of them were there enough to say, you know what, at some point, I want to be here voluntarily. That's amazing about treatment and sobriety, unlike treatment with mental health. In mental health, we deal with anosognosia, which is an aspect of the illness that doesn't even let you understand that you're sick. Interestingly enough, in most drug addiction, once you get past the effect of the addiction itself, you get to understand that you shouldn't be addicted. Does that make sense? Whereas in mental health, there isn't that aspect typically. So they come in, they take them in. It's 24 hours, not 72, not 48 hours on the hold. If you're going to go to an OPC, you have to file for an odor protective custody, chemical dependency. It requires its own forms. If we're going to have a probable cause, which we do, hearing, you have to have an attorney. If you get on to the actual odor protective custody, which detains them up to 14 days, just like in mental health, or up to 30 days before the hearing, you have to have a hearing to commit. Here's the distinction. In the old days, you couldn't have that hearing unless you had a jury trial. So unlike mental health commitment, where you have to ask for a jury trial, the current law presupposes you will get a jury trial unless the defendant or the attorneys waive. Interestingly enough, in every single one we did, they didn't care, they waived. They didn't want to have to go to a jury trial. Maybe it's because they were in the throes of their dependency, maybe because they just didn't care at that point. But you should be aware that if you're going to play with it, I call it playing with it, if you're going to experiment and probe the horizon, you need to be prepared that someone might say, oh, I want a jury trial. All right? Most people don't, believe it or not, when they're confronted with being at such a level that you're so dependent you're a danger to self or others. You have that probable cause hearing. It requires that a doctor, a physician, certify that an individual is chemically dependent and that the chemical dependency is to such an extent that you're a danger to self or others. You have those hearings, the probable cause hearings, works the exact same way. Then you'll have your your OPC signature, your probable cause hearing, and then your commitment jury trial or waiver of jury trial and hearing. I'm hoping that that's something, if we really do find some fruit in this, that we can change along the way with some statutory tweaks to make it more aligned with the mental health side of it. Okay? And then, when you read the statute, there's a little confusion, because the very first part of the statute says, a person may refuse medication, may refuse treatment and therapy. A person in treatment at a facility may The statute isn't just written as when you step back and read it about 4 or 5 times, the bell goes off. The statute isn't just written as an involuntary statute. It covers the spectrum. So if I'm in treatment somewhere, you can't make me take, if I go take treatment for my drug and alcohol addiction, you can't make me take medication. You can't make me do therapy. You can't make me do that. If you're going to make me, then you go down to the bottom part of the section that says involuntary commitment. And you can only do so if what? I'm a danger to self or others. So when you read that, don't stop at the first 2 pages and go, well, it says they don't have to take medication or treatment. That's contemplating an individual who is receiving treatment at a facility of their own accord. And then you can go further. The next section talks about what if you signed involuntarily and then you want to leave. It talks a little bit loosely about how a facility can be an applicant and say, well, we want to keep you. We don't want to let you go. Because if you go, you're going to hurt yourself or you're going to kill yourself. Now, let's go back to the 4 or 5 people that we discussed. Those weren't just individuals that were having drug and alcohol issues. They were the individuals who we identified in our community who were given Narcan 4 or 5 times, who were passed out on the side of the road, in the road, on the road, in their worst condition, who were being picked up day in and day out, taken to an emergency room, sobered up, let back out. All right. We decided, well, let's tweak this statute. Let's see if we can get them to treatment. When we got them there, again, it opened up. People started, after a few days of sobriety, especially if the withdrawal starts to kick in, they're more than happy in many occasions to work with the treatment facility, especially if that black robe effect kicks in. Well, you're not going anywhere because the judge wants you here. Okay? So for court-ordered treatment, you skip down to about the 3rd section in 462. Who can file? Like I said, it's a county or district attorney. They do the same thing. It's a sworn written application with the county clerk. There are court costs. Court costs can be waived. Court costs are assessed in the same way as they are in mental health. If they're not waived, they can be held against the county or as against the applicant or as against the, if the applicant's a private person, or as against the individual. But we all know who's got money to pay for this, right? For the most part, court costs are often waived in these types of matters. It's filed in the county where the proposed patient resides, is found, or is receiving court-ordered treatment already. Now, that's an interesting section of that statute. What does that mean? It can be filed, let's skip down, or is receiving court-ordered treatment. We need to explore that a little bit more when we start getting into the statute. Does that mean that if I've got somebody on a mental health court-ordered treatment, I can dovetail a different order of treatment for dual diagnosis? I don't know. But it sure seems to me that if we could, it opens up a lot of doors, presuming at some point we have treatment facilities that can provide beds, right? And we got to think about that. What does it have to say? Well, the application has to list who the person is, why the person is chemically dependent and dangerous to himself. It has to specifically state that the person is not under certain charges. By certain charges, they mean they're not accused at the moment of any serious aggravated offense of injury or to self or to others. So aggravated assault, not going to happen. Murder, not going to happen. All right. The guy who's criminally trespassing every 3 days, probably going to happen. All right. It has a section for emergency detention, and we have been using that, by the way, because we have decided not to let the flaw overtake the benefit. An officer can do exactly the same thing that they do with an emergency detention of mental health. If an officer believes, based on his knowledge or a credible informant, that the other person is chemically dependent, he's passed out on on heroin, the needle is laying on the floor, and that he possesses a substantial risk of harm to self or others, the mere fact that many of the individuals we initially worked with, we knew who they were and we knew what their hospitalization records were, how many times they had OD'd, helped us, and that there's not enough time to obtain a warrant. Yes, sir. Yes, ma'am.
Quick question about the dangerousness piece. As a clinician filling out the form, we're filling it out that we believe that they're chemically dependent, and as a result of their chemical dependence, they are a danger to self, others' deterioration.
Correct. The statute goes on to describe that you can base that knowledge on the circumstance, the admissions of the patient, the statements made by credible and reliable persons such as the police officer. I found him passed out with needles laying around him. He was in such a stupor, he couldn't realize the safety and dangers of his environment and was walking through the middle of the road. You know, it's about the same type of dangerousness you would get in a mental health case, but it has to be tailored towards the chemical dependency. So yes, there is a standard, just like in mental health. Yeah, you'll know it when you see it, kind of thing. All right. So a police officer can pick him up and take him in on emergency detention. So we had some brief discussion in Bexar County about, well, what do we do with this? They're just going to let him go. And the officers got together and said, I don't care. I mean, if there's a way I can get him somewhere, I don't know if he's mentally ill. If there's a way I can get him somewhere and intervene for now, other than getting him to a jail, why don't we try taking him in on an emergency detention for chemical dependency? And they do. Now, there's a pretty strong possibility that at the end of the 72 hours, when they have to file a request for order of protective custody, et cetera, that they may be discharged. But there's an even stronger possibility that once they're there, the facility themselves will say, well, I don't know about you, I may not be able to keep you on a chemical dependency, but now that you're here, you've got serious mental illness, and you're in a situation that you've endangered yourself. We're going to continue down the process. Some jurisdictions are better at that than others, depends on your resources. But we decided in Bexar County, at least amongst the team that we were working with, we weren't going to let the fact that we had no treatment beds on the back end of it deter us from at least doing what we could do, stop him from dying right now. Yes.
So the officers, I guess, in Travis County, it's a little different. There are some hospitals that you can take this to, but generally they go to ERs. Is that where the officers?
Yes. It's they can, right? It's 48 hours. They need to assess them, and I'm going to skip through a few of these to get to it. When you get them to the hospital, to the emergency room, it's the same timeline. Doctor has got to assess them within 12 hours of the apprehension, and then within no later than 48 hours, 4 o'clock, you have to file a request for order of protective custody for chemical dependency. Typically, that then holds you until your 72-hour probable cause hearing. And then further if you're on OPC.
I'm impressed that the hospitals are keeping.
Some do, because it turns out that, I mean, it's no secret. Most of the people who are that seriously intoxicated and addicted have a dual diagnosis. You know, yeah. Well, I don't want to give you the wrong example. We get a lot of discharges too. All right. We just decided that we weren't going to give up on taking them in to see if we can save their lives. Yes, ma'am.
I can answer your question. I worked in the ER at St. David's South in Austin for a number of years, and it's also, there's a caveat on funding.
Yeah.
The reason behind the emergency detention, the hospital stance generally has to adhere to the time window, but they're going to try to get it out.
Yeah. And that's a more interesting conversation, by the way, for later, that dynamic. We've never really sat down in a room with, we need you to give them treatment. And the hospital's going, we don't want to go bankrupt. But EMTALA says you have to, but we're a private hospital. I mean, there's this whole genre. You all have, what I'm not attacking, but you all have a term in the industry that I find odd. It's called throughput. Okay. Yeah, throughput, they actually time how quick they can get somebody out and discharged. I was like, huh? Well, that's different philosophies. But you know what? Despite our different views, we're kind of not doing such a bad job. We're still helping people. I wish we could. You know what the difference between a well-laid plan, cooperation, and a disaster is? Funding. I mean, that's about it. All right, so the officers take them in on the emergency detention. It works the same way. At that point, a certificate, an application for order of protective custody is done within that time. I'm going to go off script because I want to make sure I kind of discuss what it talks about. When you take them somewhere, you have to take them to the nearest appropriate inpatient facility. Interestingly enough, that is defined much more broadly in the court order treatment definitions of what a facility is. Let's see if I can find it here. Nope, didn't show up. When you look at what a treatment facility is, a treatment facility as defined in Chapter 462 isn't just a hospital. There's some discussion about whether it's been approved by the LMHA or whether it's licensed by Health and Human Services. But it goes on to say that it can be a halfway home. It can be a boarding home. It can be a community center. It can be. There's a lot of stuff it can be other than something that's required to be licensed under, I think it's 452 of the Health and Safety Code as a hospital. So you want to explore that. That's probably something we need to look at tweaking to see if, hey, why do I need to take them to a hospital in the first place? The way we do mental health, they got to do medical clearance. We take them to an emergency room clears them. Then we take them, if we can, to an available psychiatric bed if one's there. If not, that facility has to make the decision on keeping them or not if they're unfunded. So it means that there's a dynamic there, right? So we need to look at that. We need to see what the resources are to do that. Interestingly enough, in many jurisdictions, when you look at treatment, that treatment is funded in the criminal justice side. We have programs and we have contracts with treatment providers for people who are in jail. And I wonder, and that's how I got beds. I went to some of those guys and said, just give me 2 or 3 beds, man. Let me see where let me at least start thinking about it so I can go to a group of people right before they get to board their airplane and go home and think about this. Because 5 years from now, we won't still be thinking, we'll be doing. All right? That's what this discussion today is about. I'm also going to point you to, if you want to write this down, and any county court at law judges here? Yeah, you're the guys I need to talk to about this. There's a section in there that's interesting. So when you all commit somebody, when you all actually do you are hereby sentenced, you sentence them to jail, correct? You don't actually sentence them to a treatment center. You'll sentence them to jail, but you go to a treatment center and you get credit for time served there sometimes. It's been a long time since I've been a county court of law judge. Is that correct, though, mostly? You don't know because you don't do, okay. All right. Well, it turns out that section 462.081 says that a misdemeanor court judge in a county court at law where there is no statutory probate court may sentence them directly to a treatment center instead of jail. And it's a final order. So something to kind of think about. How do we start spinning that in the future to say, don't build a jail, build a treatment center. I can sentence them there instead. Minimum of 30 days, maximum of 90 days, credit for time served. You've pretty much covered every single misdemeanor that you're ever going to punish, right? So just want to challenge, again, today's discussion is about challenging you to look at it and go, how could we make that work, right? All right, so we're just about out of time. I'm going to do something that shocks people when I do this. I'm probably the only judge in Texas that does it, but it's part of that. I want to be the stone. Write this down. Don't abuse it. That's my personal cell phone number. That's my personal cell. Try not to get me a subscription to, Home Builders Magazine for years. But. Yeah, 210-865-2354. I always answer it. Try not to make it at 3 in the morning because then my wife hits me. All right. And I know we're almost done, but I want to always try to bring a little humor to this. And again, I warned you, this discussion today is not about what we're going to do and how we're going to do it. I am confiscating my own phone. Actually, that was somebody testing it. Yeah, no kidding. Darn you! Curses! That's called acting. But always, exactly. Today's discussion, I warned you, it's a wrap-up, but it's kind of just, what are the things I've played with? Do I think there's merit here? I do. Do I think that if we get serious about trying to tweak this statute, we can make it akin to what we already do in mental health? And then lastly, the section has an entire aspect to it that if there's not a treatment center, I can order them to outpatient sobriety. Yeah. So, okay, we don't have treatment centers. Let's see who we can contract to provide outpatient services for some of these people. I mean, there's fruit, there's land, there's fruit to be born, and there's land to discover. And today's discussion was just to have the very few of you who are still here today, and the face recognition caught you, by the way, who are still here today to think about it. So before I go, I always try to be humorous, sometimes successfully, sometimes not. How many of you saw this upstairs? Can you see it from where you're at? Okay, this was right next to the television up in the little business center that you have in each room. And what it is, it's a marijuana leaf with a cigarette and a big no. It says, this hotel uses advanced smoking detection that monitors for specifically detects tobacco and marijuana smoke. And I thought about it when I looked at it and thought, if only it were this easy. I was going to light up a joint, but the sign says no, I'm not. I can't. Oh, well, I guess I'll be sober today. All right, feel free. I know you guys got to go. It was my pleasure to be here. Thank you so much.
Hold on for just a moment,
Right.
please. I have some information that I need to give you. Judge Kazen.
Thank you.
Thank you. Judge Kazen is not only a commissioner with JSMH, a wonderful human being, someone who thinks out of the box, but he's also on our substance use disorder committee. And we are going to continue this conversation. And our next meeting is October the 22nd. It's by Zoom at noon. Get in touch with Andy if you'd like to be part of that committee, or if you'd just like to continue hearing this conversation about what we're going to do with this valuable information. Thank you again, Judge Kazen. Thank you again for being part of the 2025 Summit. It's been a wonderful experience, and we hope that we will see you again next year. Don't forget to go to the website for any and all information about this summit, past summits, and there's just so much valuable information at the website. Please visit it. Thank you so much again. God bless you all, and have a safe trip home.
Have a safe trip home.
Thank you so much.